Very good day to everyone. So this is our first chapter, which we are going to cover on the Malaysian legal system. So we are going to look at the introduction to law in this particular chapter. So these are the learning outcomes. At the end of this lecture, students should be able to describe the concept of law to business environment, to define law with references to law jurists, distinguish different classifications of law in Malaysia, explain sources of law available in Malaysia, and to discuss the administrations of justice in Malaysia. Okay, so these are the topics that we are going to look at. So let's look at this slide, the first slide. So in this first slide, we can see there is a weighing scale, which is a common symbol used to represent law, justice, and fairness. So this scale reminds us that the law tries to keep everything balanced in the society. So based on the picture, he explains that law is a means or device to regulate the economic and social behavior of society. So let's break this into simple words. Means or device is a tool. To regulate means to control or guide. Economic behavior means how people buy, sell, work, and do business. Social behavior means how people interact, behave, and live together. So simple definitions for you to understand is that law is a tool used by the government to control and guide how people behave in society and in the economy. So let's look at a simple example for you to understand. Example number one, let's talk about economic behavior. The law under economic behavior, every employee must be paid at least the minimum wage. Here, the government sets the minimum wage, so employers cannot pay workers too little. The second one on the social behavior. The law says, do not steal. So the law protects people's belongings so that everyone can live safely. So the tool of law, or how the law works. Now, according to the pictures in front of you, the law uses tools such as legislation and also case law. So let's explain both in a simple way. Legislation or undang-undang bertulis, so these are laws created by the parliament. Examples like Akta Kerja 1955, Akta Kanak-kanak, Akta Kesalahan Kecil. So Parliament passes a law that says drivers must wear seat belts. This is one example there. So this is a legislation. It tells us what to do. The next one is on the case law ataupun keputusan mahkamah. These are laws created through court decisions. Judges decide cases, and their decisions become guidance for future cases. For example, if a judge decides posting harmful lies about someone on social media is a defamation, future courts will follow this decision. So for simple and short summary based on this picture, law is a tool used to guide how people behave. It helps maintain order, fairness, and safety in society. The law controls both economic behavior and social behavior. Law works through two main tools. Number one is the legislation, written laws by parliament, and the second one is case law, decision made by judges. Right. On the next slide, why do we study law in business? So based on this particular slide, he says that law is a dynamic and ever-changing field. So dynamic here means always moving and developing. Ever-changing means laws are updated or replaced over time. Next is affect everyone. Every person and every business must follow the law. So laws are not fixed. They change because society changes. New problems appear, so new laws must be created. Examples like years ago, there were no laws about online scams because online shopping was not common. Now, many countries have cybercrime laws to protect people from digital fraud. This shows how the law changes to match new situation. So why business students need to know the legal environment? So there are three main reasons. Okay. The first reason is to reduce liability risk. Liability means being legally responsible for something. Businesses want to avoid being sued or punished. So if a business knows the law, it can avoid doing things that will get them into trouble. Examples like a restaurant must follow food safety laws. If they don't, customers may get food poisoning. The restaurant can be sued or fined. So by knowing the law, the restaurant can reduce risk and operate safely. Reason number two is to identify legal problems early. Another reason to study law is to recognize when something might become a legal issue. If you don't understand the law, you may not realize that you are breaking it. For example, a company uses a photo from Google for marketing. They didn't know it is protected by copyright. They can be sued for copyright infringement. So knowing the law helps you detect problems before they become serious. Reason number three is to understand the link between business and the law. Business and law are always connected. Every business activity, such as hiring workers, renting a shop, selling product, must follow legal rules. Examples: when you hire a worker, you must follow employment law, which is talking about working hours, salary, and safety. When you sell a product, you must follow consumer protection laws. Understanding the connection helps a business operate correctly and professionally. So in short, law changes over time and affects everyone. Studying law helps business people to reduce legal risk, identify legal problems, and to understand how business and laws are connected. Here in this slide, we can see a rule book with a definition, a general rule of conduct. This means that the law is basically a set of rules that tells people how they should behave. A general rule of conduct means it guides how people act. It tells us what is allowed and what is not allowed. It helps maintain order so everyone can live safely and peacefully. In other words, law is rules that everyone in society must follow. Let's look at few examples. Example number one, traffic rules. The rule says that do not drive over the speed limit. This rule protects drivers and pedestrians. If everyone follows it, accident can be reduced. Example number 2, school rules. Student must attend classes on time. Here, it teaches discipline and ensures learning happens smoothly. Next example, criminal law. Do not steal. This rule protects people's property. Without this rule, people would be unsafe. So for summary, law is a general rule of conduct. It tells people how to behave properly in society. These rules exist to protect everyone. Examples include traffic rules, school rules, and criminal law. In this slide, we can see a definition: the body of enacted or customary rules recognized by a community as binding. Let's break this into simple, friendly explanation. Number 1, body of rules. This means a collection of rules, just like a rule book collects all the rules in one place. The law collects all the rules for the society. Next, enacted rules. Enacted means officially made or written by the government or parliament. Parliament passes an act, such as the Employment Act. This is an enacted law because it is written and approved by the government. Next, the customary rules. Customary means traditional practices or customs that people follow for a long time until they become accepted as rules. These rules are not written in a book, but the community knows and follows them. Example, in many communities, land is passed down according to tradition. Even if it is not written in a statute, people follow the custom. Recognized by a community. This means that people accept these rules. A rule becomes law only if society agrees that it should be followed. Example, everyone agrees that stealing is wrong. That's why it becomes a rule recognized by the society. Next is on binding. Binding means you must follow it. You cannot ignore it. If you break it, there will be consequences or punishment. Example, if you break traffic laws, you will be fined. This shows that the rule is binding on all drivers. So putting it all together, the definition means law is a collection of written rules and traditional customs that society accepts and must follow. These rules are mandatory, not optional. So in short, law is a set of rules for society. It includes written rules, the acts, and custom, which is the traditions. These rules are recognized and must be followed by everyone. Breaking these rules brings legal consequences. Here, we can see John Salmond and John Austin, law defined by them. According to John Salmons, he says, the body of principles recognized and applied by the state in the administration of justice. According to Salmond, law is made up of principles, which is the rules or standards, that the state here refers to government, courts, and legal system, recognizes and uses when delivering justice. In other words, the state decides which principles are officially considered law. These principles are then applied in courts to settle disputes and give fair decision. Let me give you some example. The principle of innocent until proven guilty is recognized by the state. When someone is charged in court, the judge applies these principles to ensure fairness. This shows that law is a set of principles used by state to reach justice. Next is on John Austin's definition. A command set by a superior being to an superior being and enforced by sanction. Austin focuses on three key ideas. Number one, command, which is law is an order. Number two, superior and inferior. It is given by someone with authority that refers superior to the people, which is the public, the inferior. Sanction, if the rule is broken, punishment must follow. So in simple words, we can say that the law is what the government commands us to do. If we disobey, there will be consequences. Let me give you an example. The government commands do not drive above the speed limit. So people must obey. If someone breaks this rule, they receive a traffic summons or fine. This shows the idea of command and punishment. So for summary, under Salmon, law is principles used by the state to ensure justice. Under Austin, law is command from authority and punishment if disobeyed. So both definition helps us understand how law functions in society. Next, on the classifications of law. In Malaysia, our legal system is based on the common law system. This means many of our laws come from English legal traditions, court decisions, and written legislation. So here, the law is divided into three main categories. The first one is public law. Public law governs the relationship between individuals and the state. This means when a person deals with the government, government's power, or offenses against society, it falls under public law. So there are two types of public law. The first one is constitutional law. It deals with the powers of the government and the rights of citizens. For example, the federal constitutions, which talks about freedom of speech, citizenship, separations of powers. The second type of public law is criminal law. It involves offenses against society. Examples like thief, murder, robbery. So if a person commits a crime, such as stealing, the case is between the individual versus the state. So this is public law. The second category is the international law, which consists of principles and rules that countries agree to follow in their dealings with each other. These rules keep peace, ensure fair treatment, and guide how countries behave internationally. So there are two types of international law. The first one is public international law. It governs relations between countries. Example, treaties on human rights, environmental agreements, maritime rules. The second type of international law is private international law. It handles disputes involving citizens or companies from different countries. Example, a Malaysian company suing a Japanese company. So if Malaysia signs a climate change agreement with other nation, this is public international law. If a Malaysian woman marries a German man and their divorce involves two nationalities, that is private international law. So the third category is private law, which it governs matters that affect the rights and duties of individuals in their private relationships. This is law between person versus person, not person versus government. So there are three types of private law. The first one is contract law. It is an agreement between individuals or business. Example, buying a car, signing a work contract. The next one is tort law. It is a wrongful act that cause harms to other person. Examples like negligence and defamation. Trust law, managing property or assets on behalf of someone else. Examples like estate trustees or family trusts. So, simple example, if A borrows money from B and refuses to pay back, this is private dispute. B can sue A in civil court. So this is private law. Okay, so let's continue on the sources of law. So the sources of law in Malaysia. So it comes from three main sources: written law, unwritten law, and Islamic law. So let me explain each one clearly. Number one is written law. It refers to laws that are formally written, documented, and passed by the government. These are laws you can read in acts, constitutions, and official publications. Written law includes federal and state constitution, which is the highest legal authority in Malaysia. It contains fundamental rights, government structure, and powers of state. Example, the federal constitution guarantees freedom of speech, citizenship rules, and many more. The next one is legislation enacted by parliament and state assemblies. These are written laws made through the law-making process. Parliament makes federal laws. State assemblies make state laws. Example, Employment Act, Road Transport Act, state Islamic laws. The next one is subsidiary legislation. These are laws made by authorities below parliament, such as ministers, local council, or agency. They are also called regulations, rules, orders, and bylaws. Example, local council parking rules or health regulation. The second one is on unwritten law. Unwritten law does not mean not written anywhere. It simply means it is not written in a single act or constitution. These laws comes from historical practices, court decisions, and tradition. So unwritten law includes English law, Malaysia adopted part of English legal principles during the British colonial period. English law fills gaps where no local law exists and is still used as a reference. For example, company law principles originated from English law. The second one is case law or judicial decisions, which is also known as precedents. These are decisions made by judges in court cases. If a judge decides a case today, future judges must follow the same reasoning in similar cases. For example, if a judge decides that online harassment is defamation, other courts may follow that decision. Next is customs, traditional practices followed by local communities for generations. Customary laws must be reasonable, accepted by society, not against written law. For example, native customary rights in Sabah and Sarawak, Malay customs relating to family matters. So the third source of Malaysian law is Islamic law. Islamic law in Malaysia applies mainly to Muslims and deals with personal and family matters such as marriage, divorce, or inheritance. It also deals with religious duties and morality and Islamic conduct. Islamic law is administered by Sharia courts and state Islamic authorities. For example, rules for Muslim marriage and divorce under state Islamic enactments. Next is on the Constitution. Here in this particular slide, it shows the Malaysian Federal Constitution, which is the highest law of the country. Everything in Malaysia's legal system must follow the Constitution. The Constitution performs two major functions. The first one, it lays down the powers of the federal and state governments. The Constitution divides and explains what the federal government can do and what the state governments can do. It tells us who has the power to make laws, who controls education, health, criminal law, land matters, and many more. How the government is structured, either executive, legislature, or judiciary. This prevents the federal and state governments from abusing power or interfering with each other. For example, federal government controls matters like defense, finance, and national education. State government control matters like land, forestry, and Islamic affairs. Both sides must follow the constitution when exercising their power. Number two, it enshrines the basic and fundamental rights of individual. The Constitution protects the rights and freedoms of every person in Malaysia. These rights cannot be taken away without a valid legal reason. Examples of fundamental rights in the Constitution are, number one, right to life and personal liberty. Number two, right to equality before the law. Number three, freedom of speech. Number four, freedom of religion. And the last one, right to education. These rights ensure that individuals are treated fairly and have protection against unlawful actions by the government. Example, if a person is arrested, the Constitution requires that they must be informed of the reason, brought before a magistrate, and given a fair trial. This prevents abuse and protects human rights. For summary, the Constitution is the supreme law of Malaysia. It defines the power of the federal and state governments. It protects the basic rights and freedoms of every individual. All other laws must follow and respect the Constitution. Next is on the legislation. Legislation refers to law that is enacted by the constituted law-making body. In Malaysia, laws are created through parliament at the federal level and through state legislative assemblies at the state level. So what is legislation? Legislation is a written law created by the government. These laws go through a formal process before they become enforceable. In simple words, legislation is laws made officially by parliament or state assemblies. Number two, who makes legislation? The first one is the parliament, which is the federal level. Parliament creates laws that apply to the whole of Malaysia. These laws are called acts. Examples like Contract Act, Road Transport Act, Employment Act. These laws applied nationwide. The next one is state legislative assemblies, which is the state level. State governments can also create laws, but only on matters listed under the state list, such as land, Islamic law, and local council. These state laws are called enactments. Examples like state Islamic law enactments and land enactments. These laws apply only within the respective state. The third one is types of legislation, the acts. Okay, the acts, these are laws passed by the parliament. They cover issues that affect the whole countries. The next one is enactments. These are laws passed by state legislative assemblies, which only apply in the specific state. And the last one is ordinances, which are special type of legislation used in certain situations. In Sabah and Sarawak, many laws were originally made during colonial times. Before 1957, some laws were passed as ordinances before independence. During the emergency, the Yang di-Pertuan Agong can make ordinances when Parliament is not sitting. Ordinances have the same force as any other written law. So for summary, legislation means written laws created officially by the government. Parliament makes acts. State assemblies make enactments. Ordinances apply in special cases such as in Sabah and Sarawak, pre-1955, and emergency laws. Next is on the subsidiary legislation. It refers to laws made by authorities other than Parliament or the state legislative assemblies, but under powers given to them by the parent. or primary legislation. In simple words, Parliament makes the main law or parent act and give permission to certain authorities to create detailed rules. So these detailed rules are subsidiary legislation. So based on Interpretation Act 1967, any proclamation, rule, regulation, order, notification, by law or other instrument made under any ordinance, enactment, or other lawful authority and having legislative effect. For simple explanation, subsidiary legislation includes regulation, rules, orders, bylaws, notification, and proclamation. All of these are legally binding and have the force of law. So who makes subsidiary legislation? Subsidiary legislation is made by authorities such as ministers, government agencies, local councils, professional bodies, and statutory authorities. But they can only do so if the Parent Act gives them the power. So, what is the Parent Act? The Parent Act is the main law, such as act, enactment, or ordinance passed by Parliament or state legislative assemblies. This Parent Act gives specific powers to an authority to create additional rules, such as Road Transport Act. It gives the minister power to make traffic rules. So, Road Transport Act is Parent Act. The traffic rules is subsidiary legislation. So, why do we need subsidiary legislation? Or what are the importance of having subsidiary legislation? So, there are two key reasons. The first one, legislation is insufficient to provide all the laws. Parliament cannot possibly write every small detail inside the main act. The Parent Act gives the general framework only. Number two, subsidiary legislation deals with the details. It fills the specific need for day-to-day implementation. For example, Parliament passes the Food Act, but the Ministry of Health writes detailed food hygiene regulation. Another example, Parliament passes the Local Government Act, but local council creates bylaw on parking, hawkers, and waste disposal. Without these details, the main law cannot function effectively. So, for summary, subsidiary legislation is detailed rules made under authority given by the Parent Act. It is made by the ministers, agencies, local council, and many more. It needed because Parliament cannot include every detail in the main act. It contains rules, regulations, bylaws, order, notification, and many more. It helps the law work smoothly and practically. English law. In Malaysia, English law is one of the sources of law. This comes from Section 3 and Section 5 of the Civil Law Act 1956, which allow Malaysian courts to refer to English legal principles when needed. So why do we use English law? English law was introduced during the British colonial period. Even after independence, Malaysian courts may still refer to English law to fill in gaps where no Malaysian law exists. These supported by Section 3 and Section 5 of the Civil Law Act 1956. These sections state that courts may apply English common law and equity principle. However, there are two important limitations. In Section 3, does not allow English law to be used freely. It can only be used when two conditions are met. Number one, the absence of local statutes, meaning Malaysian courts can only apply English law if there is no Malaysian law on that specific issue. For example, if Malaysia already has the Contract Act 1950, the court must follow Malaysian law. English contract principles can only be used to support or explain, but not to replace the Malaysian law. So, English law acts as a backup, not the main law. The second limitation is suited to local circumstances, meaning English law can only be used if it makes sense and is suitable for Malaysian conditions. Malaysia is different from England in culture, social values, climate, lifestyle, and local practices. So if an English principle is not suitable or irrelevant to Malaysian society, the courts will not apply it. So for simple example, English law on winter road condition is not relevant in Malaysia's tropical environment. Therefore, it will not be applied. So for simple summary, English law helps Malaysian courts fill gaps when no Malaysian law exists. However, it can only be used if, number one, there is no Malaysian law, and two, it is suitable for Malaysian society. The doctrine of judicial precedent. The doctrine of judicial precedent is a fundamental principle in the legal system, especially in countries that follow the common law system like Malaysia. This doctrine ensures that court decisions are consistent, predictable, and fair. Number one, judicial decisions of the courts. Here in these slides, it tells us that judicial precedence is based on judicial decisions. Judicial decisions are the written decisions made by judges at the end of court cases. These decisions explain the facts of the case, the legal issue, the judge's reasoning, and the final outcome. These written decisions become guidance for future cases. Number two, what are precedents? Precedents means decisions made by judges in similar condition. A precedent is a past court decision that must be followed when a new case has similar facts, similar issues, and similar legal principle. This is because courts want to make sure similar cases receive similar decision, and these create consistency in the law. So how does it work? For example, in case A, which is decided earlier, a judge decides that posting harmful lies about someone online is defamation. In case B, which is now happening currently, facts are similar, harmful, false statements posted online. So what happened? The new judge must follow the decision in case A because the conditions are similar. This is judicial precedence. So why is judicial precedence important? Number one, to ensure fairness. People with similar cases get similar outcomes. Number two, creates stability. The law does not change randomly. Number three, it saves time. Judges do not need to reinvent decisions. And the last one is it provides guidance. Lawyers and the public can predict likely outcome. Customs are one of the unwritten sources of law in Malaysia. They refer to the practices, traditions, and behaviors of the local inhabitants that have been followed for a long time and are accepted by the community. In simple words, customs are traditional practices of local communities that are recognized and respected as rules of behavior. For a custom to be accepted as a source of law, it must be long established, widely accepted, reasonable, and not against written law. Customs in Malaysia. In these slides, it highlights four major groups whose customs influence Malaysian law. The first one is Malay customs. Malay customs or adat Melayu include marriage and family practices, inheritance traditions, cultural ceremonies such as akad nikah and akad bersanding, etiquette and social behavior. Some Malay customs are recognized under state Islamic enactment. Number two, Chinese customs. Chinese customs influence marriage and family matters. For example, traditional tea ceremony, funeral rites, ancestral practices, business tradition such as trust based on partnerships. Certain Chinese customs are historically recognized under the Chinese customary marriage ordinance before reforms. The third one is Hindu customs. Hindu customs include traditional marriage ceremonies, family and community rituals, religious observances, cultural events like Deepavali and Thaipusam. Some customs apply in personal and religious matters, especially before codified laws existed. Native custom in Sabah and Sarawak. Native groups in East Malaysia, such as the Kadazan Dusun, Murut, Bajau, Iban, Bidayu, Orang Ulu, and others, practice native customary laws. These customs cover land rights or native customary rights, NCR, marriage and divorce, inheritance, local dispute settlements. Native customs are formally recognized under Native Court Ordinance in Sabah and Native Custom in Sarawak. So in summary, customs are long-established traditions of local communities. They form part of Malaysia's unwritten law. Recognized customs include Malay customs, Chinese customs, Hindu customs, native customs in Sabah and Sarawak. Customs must be reasonable, widely accepted, and not against written law. Muslim law, also known as Islamic law or Sharia law, is one of the sources of law in Malaysia. It applies only to Muslim and it deals mainly with personal and family matters as provided under the stat list of the federal constitutions. These slides highlights three key elements. The first one is Sharia courts. Sharia courts are separate courts from the civil courts system. They have authority over matters involving Islamic personal laws such as marriage and divorce, inheritance or faraid, child custody, religious observances, offenses under state Islamic enactments. These courts operate within their own jurisdiction and their powers are limited by the federal constitution, state Islamic laws, and state Sharia court enactments. So, for example, if a Muslim couple wants to divorce, the case goes to the Sharia court, not the civil court. Number two element, it applies to Muslim. Muslim law applies only to persons who profess the religion of Islam. This means civil law applies to everyone in Malaysia, but Sharia law applies specifically to Muslim and only in areas permitted by the state list. Muslim must follow Islamic family laws, Islamic inheritance laws, rules of marriage, divorce, custody, and wakaf. For example, a Muslim man who wishes to marry must follow the Islamic family law enactment of his state, including akad nikah, registration, and wali requirements. The third element is made by the states. Islamic law in Malaysia is state-based, not federal. This means each state has its own Islamic family law enactment, Islamic criminal offences enactment, and Sharia court enactment. Because state control Islamic matters, the law can vary slightly between states. Example, Selangor may have different procedural requirements for marriage than Johor. Sabah and Sarawak have their own Islamic ordinances. So for summary, Muslim law is Islamic laws governing Muslim in Malaysia. It applies only to Muslim and deals with personal and religious matters. It enforced through Sharia courts, which are separate from civil courts, and Islamic laws are created at the state level, not federal. Next is on the judicial system in Malaysia. So Malaysia's court system is divided into superior courts or higher courts and subordinate courts or lower courts. Each court has different powers and handles different types of cases. Let's look at superior or higher courts. These are the highest courts in the country. They handle serious cases and appeals from lower courts. Number one, the federal court. It's the top and the highest court. The functions are, it hears appeals from the Court of Appeal, handles important constitutional issues such as citizenship, powers of government. It is the final court. No further appeal after this. If a case is appealed all the way up and the federal court makes a decision, that decision is final. The second superior or higher courts is Court of Appeal. The functions are, it hears appeals from the High Court, both civil and criminal. If someone is not satisfied with the High Court decision, they can appeal here. Example, if the High Court finds a person guilty, the person can appeal to the Court of Appeal to review the decision. The third one is the High Court. So the High Court in Malaysia, the first one is High Court and the High Court in Sabah and Sarawak. So what are the functions? Number one is civil jurisdiction. It handles cases involving more than 250,000, except tenancy, accidents, and distress action, which may go to Sessions Court. The second function is on the criminal jurisdiction. It handles all criminal cases, including the most serious ones. Only the High Court can try cases punishable with death. Simple example, a murder trial must be heard in the High Court. Okay, so those are the superior or the higher courts. Now let's move on to the subordinate or the lower courts. Next is the Session Court. The civil jurisdiction, it handles claims above 25,000 and up to 250,000. For tenancy disputes, accidents, and distress. For the criminal jurisdiction, they can hear all criminal cases except those punishable with death. Example, a robbery case not involving death can be tried in the Session Court. The last one is the Magistrate Court. The civil jurisdiction, it handles claims below 25,000. Sometimes higher limits apply depending on the type. The criminal jurisdiction handles less serious offenses. They can impose up to 5 years imprisonment, fined up to 100,000, and up to 12 strokes of whipping. For example, a shop thief case or a minor assault case is usually handled in the magistrate court. Overall, superior courts, number one, federal court, it's the highest appeal and the constitutional issue. Second, Court of Appeal, it hears appeals from High Court. The third one is High Court, which covers on serious civil and all criminal cases, including death penalty. Subordinate courts, number one is the Session Court, civil up to 250,000, all criminal except death. And the last one is the Magistrate Court, minor civil, less than 25,000, and minor criminal cases. For real life example, if it's a murder case, then we will go to High Court. If it's a robbery case, we go to Sessions Court. If it's deal with small debt claims at 1,000, then we go to Magistrate Court. Appeal against High Court decision, then we will go to Court of Appeal. And if we have final appeal on important national issue, then we will go to the Federal Court. So for summary, the law is a tool to regulate and control the society. The law functions like a guideline for how people should behave in society. It helps prevent conflicts, maintain order, protect people, ensure safety, and promote fairness. When everyone follows the law, society can live in peace and harmony. Number two, Malaysian legal system is based on the common law system and partly Islamic law. Malaysia uses a mixed legal system, mainly common law system, which is inherited from the British colonial area and relies on written laws and judicial precedent. used for most matters: criminal law, commercial law, contract law, tort, and etc. Next is the Islamic law, which is partly used, which it only applies to Muslims, covers personal matters such as marriage, divorce, inheritance, and religion. It enforced through Sharia court. So for summary, law keeps society peaceful by controlling behavior and preventing disputes. Malaysia uses two legal traditions, which is the common law and Islamic law. Thank you.